Hello, everyone. My name is Alexandre Pacheco da Silva, and this is Law and Technology series, a set of interviews with incredible scholars to discuss the impacts of new technology in the legal field. I am a law professor at São Paulo Law School at Getúlio Vargas Foundation, and I coordinate with Professor Marina Pfefferbaum, the Center for Education and Research in Innovation. Today, I'm very happy and pleased to have Professor Roger Brownsword, who has been an academic lawyer for some 50 years, first at the University of Sheffield and then at the King's College London, where he was founding director of Telos in 2007. Professor Brownsword has published about 20 books, most recently Law, Technology and Society, Reimagine the Regulatory Environment, and he also published more than 250 chapters in books and articles. Just to mention a few examples of his research, his interest in law, technology, and regulation, his interest in legal theory, common law, law and bioethics, among other topics that he wrote and he actually speak about. So thank you once again for accepting our invitation, Professor. It's a pleasure to have you with us today. Our interview is divided into three questions. The first one, it is, how is technology impacting the legal field? Again, thank you to be a part of this project, Professor. Go ahead.
Well, thank you very much, Alexander, and to your colleagues. Yeah, I'm speaking, of course, from the UK, and so my perspective is a little bit European. But you know, I think one of the striking things about the question here is, well, it's impacting everywhere. Technology is impacting everywhere, and just what we're doing here today and how we're doing it. I mean, you know, here we are, a conversation between lawyers in Brazil, lawyers in Europe. And the instrument of our conversation is of course, relatively new technology because the online environment is still, for my generation, relatively new. And certainly Zoom calling, or you know, the equivalence is pretty new still. But most importantly, what we're talking about, what we have a common interest in, is law and technology. And I think when you read through the various interests I've had in research over the years, much of that interest in, there's been a little bit of interest maybe to other common lawyers or other private lawyers, but law and technology is something that is of global interest. And one of the books you read out at the start weren't quite right up to date, but one of the more recent books, Law 3.0, which has been translated into Chinese, sold thousands of copies in China already. I mean, it's astounding that, people in Asia want to be reading what I think about law and technology, but it's kind of common. So now, to answer the question more directly, in a less personal way, how is law being impacted by emerging technologies? Well, as I say, almost ubiquitously everywhere you look. But the obvious place to start with would be the impact on laws themselves. And whether you're thinking about the questions that are raised for the courts as new technologies appear, and people think maybe they've been harmed, or there's some interesting question to be asked in relation to court. That becomes a question in a court-based action, or before something like a patent, body. In fact, I mean, my own initiation here 30 years ago was in relation to the patentability of biotech, where patent offices around the world were being asked awkward questions about the patentability of new genetic products and processes. But it's not just the courts, of course. More importantly today, I'd say that in most jurisdictions, we find that there's a need to put in place a kind of regulatory deal for these new technologies, particularly something like AI, but crypto technologies too, where we want to have a clear kind of governance framework that lays down the ground rules for the application of these technologies, where we think the red line should be drawn, and where we think there should be encouragement and incentivization for this kind of innovation. So these are questions really that judges and courts aren't ideally geared up for answering. These are more policy questions which the political branch has to deal with and eventually make laws which articulate a framework for these new technologies. And of course, it's very challenging because the technologies aren't standing still while the regulatory deal is being put in place. You know, I was just looking at the progress with our own in the UK online safety bill, which has been negotiated here for years, you know, and all the time, the questions we have about online safety or online content are changing. You know, this is, you know, well, yeah, so I mean, ChatGPT, for example, presents problems in relation to online content as to its pedigree and authorship, its authenticity. But online safety is about something rather different, you know, so the world moves on. So the first place we find technology impacting, and in a highly problematic way, is in both courts and in legislative or regulatory assemblies, and in relation to the rules or the principles that we have for our governance of these technologies. But also, of course, the accessibility and the form of these rules and principles is now changing. So, I mean, if until fairly recently I'd wanted to check out the latest state of progress with the online safety bill, which I just mentioned here in the UK Parliament, I'd have to have gone to a law library, and I'd have to have a look to see where we were with, you know, the paperwork. But now, of course, I can just Google that question and find out straight away online where exactly we are at in the timetable for the completion of that particular piece of legislation. And I can read, you know, there are over 300 pages of it, but if I wanted to read it, the draft bill as it currently stands is available for me to read. So, you know, the accessibility and the form in which our laws are written is changing all the time. And of course, as you know, there's a considerable interest in the possibility of producing laws which are machine readable so that we can automate the application, interpretation, and enforcement of laws in a way that takes the human element out of the equation. So that's one place. And secondly, another place where it's been very obvious for a long time that technologies are an important factor now on the radar is in relation to law enforcement and in the criminal justice system, where new tools are being made available all the time for the identification of persons, for you know, recognition of persons, tracking, tracing, all sorts of things which in the criminal justice are thought to aid with the detection of crime, or indeed also to prevent crime, but primarily I think still to assist the enforcement authorities where a crime has been committed. Then of course, again, in the law schools, we're concerned with, largely we're thinking about the skilling of future legal practitioners, and already legal practitioners are making use of these new tools in all sorts of ways. This is something quite recent, I think, because my interest in law and technology began with biotechnology, and to a lesser extent with information technology. But I think it's been in the more, you know, particularly with AI and machine learning, that we see the legal profession incorporating rapidly new tools which are very, you know, will take out a lot of the difficulty out of labor-intensive work, which low-level work, which they would otherwise have to do. You know, I mean, if lawyers are having to do due diligence in some way as part of their practice, AI can scan through documents in a fraction of the time, but it takes a team of humans to work through the documentation. So there are all sorts of ways in which law practices are now gearing themselves up for the use of tools which will take over the functions that they've traditionally performed. I mean, whether it's be, like I say, the kind of documentary work, or, I mean, advising in litigation, where it's unclear how the law stands. It may be that AI tools will be able to give legal practitioners, as well as their clients, an initial steer on how they think the case might come down if it were to go to trial. In dispute settlement, eBay, I suppose, led the way there with online dispute resolution. But I mean, for a long time now, we've been thinking about alternatives to very expensive court-based procedures for resolving disputes. But that side of, you know, that part of governance of resolving disputes, there again, we're drawing on new technologies all the time to try and make it a smoother, faster, more convenient process. And last but not least, I've already mentioned the law schools, but my goodness me, the experience of law students today is so different to the way it was in my time. And I mean, we're coming up now, I'm not sure how it is in Brazil, but in the UK, we're approaching the beginning of the new academic year, and first-year law students coming into university. In my day, the top priority was to give those students a tour around the law library Say, you know, here are the legislation, here's the cases, here are the law reviews. You know, you'll be spending an awful lot of time in this law library. This is your kind of laboratory. Nowadays, of course, because of the digitization of legal materials, it is easy for students 24/7 to access the laws that, you know, including the articles that they want to read, where otherwise there would have been pressure on scarce resources. They can read the law where they want. In a way, I was just saying I could check the online safety bill without leaving my flat here and without leaving my house any time of day. So it's a very, very different world that we live in, and technology is what makes the difference. And again, going back to my time you know, as a student, and for many years as an academic lawyer too, technology was not on the radar for us as academic lawyers. It didn't seem to be salient, didn't seem to be significant. And then about 30 years ago or so, we begin to be thinking, particularly with biotech and information technology, that technology might be of some interest to us, not just to IP lawyers, but more generally to lawyers. But very much so in terms of the kind of challenges it would present to us as we try to write new laws to lay out the ground rules for applications of this technology. So the tech initially was seen as being a challenge for lawyers who were pretty conservative in their habits and who were relying in the common law world, well, and in the civilian world too, on sort of historic principles to try to accommodate these new technologies as they arrive. But now I think we also see that these technologies present themselves as opportunities for governance in ways that, well, could be very beneficial, but could be quite harmful actually. But you know, there's a mixture of challenge and opportunity. But technology, however you view it, is really central to our thinking these days as lawyers. So our perception of technology has changed dramatically. So that's where I start with that, but it's everywhere, technology and its impact on the law.
That's very interesting, Professor, and I share the vision that you actually depicted for us regarding the law library, because when I was a law student back here in Brazil, the first thing that professors did to me, it was actually introducing the library, introducing the law reviews, and actually saying the same thing that you did and other professors in England. Say that this is your laboratory, this is the place that you will spend a lot of time, and it is important for you to understand how to navigate in this environment and how to use in your favor to do your tasks, so on and so forth. So it was very interesting to think about this change, because nowadays, if we look to our libraries here, we will see some students, but not the same amount of students that we had in the past. It is very interesting to understand how this could reshape our environment in the law school. But let me move for the second question. Professor, we have a discussion here in Brazil, and in other interviews, I can say that in other countries as well, about this idea to create a field that we can call law and technology. In your view, is there a field of study that we can call law and technology? Because some professors would say that we can have a course in law and technology. Some would say that we have a field of research in law and technology. Some would say that we need to understand technology impacting all of law and legal fields, and everyone should discuss technology. What is your view regarding that specific discussion?
Yeah, thanks, Ozan. That's a good question. And I think this is a very important question, of course, because in one sense, it's a simple answer, because I mean, I think of scholars or academics as having, to use your words, a field of interest, a field of inquiry, which is simply the phenomena in which they have an interest. Now, of course, in the case of law, as traditionally understood, the field has been sort of self-selecting. Like if you're an English lawyer, then English legislation, English cases are kind of the field of. If you're a comparative lawyer, then the field is extended. If you're an international lawyer, it extends again. But likewise, if you're a Brazilian lawyer, then Brazilian and the civilian, Portuguese civilian countries that or French, they maybe become the field. But in a way, you don't have to. Up to a point, you don't have to defend that. I think you can say, look, this is just what I'm interested in. But if someone says to you, then, well, yeah, but is there any coherence in this field, or is it just a kind of, well, a ragbag of things? It's too eclectic. There's no coherence about it. Now, famously, when the early cyber lawyers met in Chicago in the late 1990s for the first big conference on what they were calling cyber law, this was met with a response that by Judge Frank Easterbrook, who was a local judge, but also, what I'm going to say, a local academic in Chicago, that it was fine, of course, for his colleagues to be interested in computers and hardware and software and laws that related to these matters. But the idea that we should come up with some cyber field of interest, computer scientists, their field of interest is computers and software and whatnot. Fine, but lawyers have a legal field of interest. And for Easterbrook, the legal field of interest was primarily the general principles of law that we'd find in the common law world in those, base subjects like contracts and tort and property and whatever, criminal law. So that if there were a question about, say, a liability issue in relation to a computer or an IP question, you don't need to think you're going into some specialized area of law for this. You would rely on the general principles. And so, he was resistant to this idea that we should expand the legal field beyond anything that we traditionally regard as being absolutely central to the building blocks of law, whether you're in the civilian world or the common law world. Now, everybody in law and tech has their own view about why Easterbrook was wrong about this, and my own take on this is that he was wrong. Well, for two reasons. One was that he didn't appreciate, I think, that the responsibility for lawmaking or responding to questions about the application of these technologies was shifting away from the courts to the regulatory and legislative bodies. Although it is true that, and of course this was in the late 1990s, so there weren't that many big regulatory deals that had been done for new tech at that stage. But so before legislators or regulators get their acts together with laying out the ground rules for a new technology, there can be quite a lot of cases that will go into the courts for as they did with the internet, where, for example, in the early days there were quite a lot of cases around the world where there were challenges in France or Australia or America to content that people objected to online, and some of this was alleged to be defamatory and whatever. So there were judges are sometimes asked questions, as indeed they were in the earlier days of industrialization when legislative bodies hadn't had such a high profile, where they're being asked really to be inventive or imaginative in the use of the general principles of law in a way that will field the problem that's coming up. So, again, a famous example was Warren and Brandeis's article on the right to privacy in the Harvard Law Review, again, at the end of the 19th century, where, they judged that the use of cameras is unacceptable at that time. And tort law doesn't seem to have a direct answer to that, but they're saying, well, but nevertheless, as creative common lawyers, we can find a right to privacy within the idea of tort law and develop protection around that. And in fact, Warren and Brandeis go out of their way to say something like, we do not need to trouble the legislature with this issue. We can field it. But I think what's changed dramatically in the century from Warren and Brandeis up to Easterbrook and beyond is that we don't look to the courts and judges except in an emergency, really, to deal with these problems anymore. I don't think it's right, because, you know, in modern democracies, people expect to have a say in these matters through their politicians, and politicians are politically accountable. You know, how far you want to incentivize or encourage AI, what you think the risks of AI are, what needs to be protected against. You know, our constituencies need to be involved in conversations about this. So I think that Easterbrook was wrong in saying that we can just go on dealing with these questions in the way we always have previously dealt with them, by reliance on our legal imagination as lawyers, and on the general principles, which of course are very flexible, but we can go a long way with the principles of contract and tort law, property law. But I think the more satisfactory answer is that we do need to have the regulatory and the political branch involved in making laws which balance up the arguments about how far we want to incentivize and encourage these and support the innovation, and how far we want to guard against the risks against it, and what the best balance is there. But I think Easterbrook was wrong in another way as well, which another thing he didn't anticipate was the extent to which these new technologies were going to be making themselves available as tools to be used for governance purposes. And we're going to stand initially alongside law in the way I said earlier in the criminal justice system. Criminal laws can be supported by CCTV or other surveillance technologies, DNA profiling, facial recognition, you know, a whole raft of technologies that can be used to support criminal laws. But we also think that that these technologies might, in due course, be deployed in ways which would take the rules of law out of the equation. We'd find ourselves in what I'd call technologically managed environments, where we no longer have the practical option to opt in ways which regulators don't want us to act in, or they take humans out of the loop by removing them from governance, you know, whether as officials. So we automate the processes, and you know, that's just a sea change. Now, it's not just cyber law there that's significant. I mean, it's any kind of law which is, any kind of technologies which are now being picked up to do governance work. And what I would say, I mean, I've struggled to find a way of framing the whole field so that it's coherent. And in the book you mentioned in the introduction, Law, Technology and Science Society, Reimagining the Regulatory Environment, I thought at that stage that if we talked about the regulatory environment as being our field of interest, that would open the door to us to be said, well, you know, the regulatory environment, of course, part of it are these legal rules and principles that we have. Part of it, less formal rules and principles, maybe ethics as well, because that gives us some normative guidance. But crucially, we've opened the door to allow technologies to be introduced into this matrix, so that we see this as the overall regulatory environment. However, I now think the better way of doing this is to talk about not so much regulatory environment as governance, and good governance in particular, being our field of interest as lawyers. So, you know, there was a time when I think I would have distinguished between law and regulation and governance. And if you were asking me, well, what space specifically does governance cover there relative to law and regulation? I say, well, governance is less formal than law. You know, it can be informal codes and codes of practice. It can be subnational, but it can also be transnational in a way that we have informal, you know, merchant practices or whatever historically, you know, can develop transnationally. Or it could be, again, technology. That's what we're talking about, where we deal with governance. But now I prefer to say, let's not try to contrast governance with law and regulation, but understand governance in a broad sense as encompassing our attempts to direct and channel conduct and to deal with disputes, to allocate authority, to do governance things, but understanding that within the broad area, under the broad umbrella of governance, we can have specifically law, which does this through rules and with humans, or we can have it, you know, in ethics, or we can have it with technology, or technology in conjunction with laws. And I think that, yeah, that's the way I would try to say now that we should be thinking about the field of law and technology as another way of expressing our interest in governance. And I'd also say, if I may, Alexander, that you know, one of the features of regulatory thinking, which will be part of this, is that it tends to focus on questions about the effectiveness of regulation. Regulatory theorists are troubled where regulation doesn't have the intended consequences. Quite rightly, you know, they want it to be effective, but they tend not to have that much concern with legitimacy or acceptability. And I think that's really, as lawyers, what we really, you know, lawyers are very interested in justification, and we tend traditionally to limit ourselves to justifying our laws and our decisions by reference to a particular legal system within which we're operating, very closed in. I think we have to go outside that to find the reference points for good governance globally. But you know, I think governance is, yeah, governance is the name of the game. I now think we're in, and there's no doubt about it. Technology is part of, is a kind of, you know, any kind of implication of technology here in performing governance functions is about governance. Yeah. So yeah, that's the answer, I think, to the second question. I think there is a field of knowledge we can call law and technology. I'd rather call it governance, but yeah, law and technology is there.
It's very interesting, Professor, because one of the things that I also totally agree with you, it is that we also not only comment on Judge Easterbrook ideas about cyber law, but we also criticize Judge Easterbrook in our first class about the subject. It is interesting to see that everyone will actually talk about Judge Easterbrook and have her or him own opinion regarding his position about cyber law. But another aspect that actually allow me to introduce you to the third question and the final question for our interview today, it is that one of the things that we discuss a lot, it is what should the law school do regarding the impacts of technology in the legal field. Mainly, we are discussing here at FGV a lot about how can we actually address the complexity of our reality. But one thing that you mentioned that we are discussing a lot, it is, should we spend more time discussing governance, and especially governance in terms of technology? And one of the things that we actually realized, it was that in our curriculum, we do not have several opportunities to actually dedicate time to governance. Usually, we dedicate our time in legal theory, regulation, topics that are that we are much more comfortable to discuss as lawyers, as academics. And one of the things that I mentioned when we are discussing the possibility to expand the time that we actually spend with governance, one of the things that people mention and comment, it was that are we prepared to discuss governance in a deeper sense? We have the proper training to do so. Governance is a part of the type of skills that we have as lawyers and as academics. That was one good questions about the topic that you mentioned, and the final question that I have for you, Professor.
Well, thanks very much again. I think the question of how the law school should respond to these developments is, I mean, obviously for us in law schools, is of paramount interest, because while everything has been changing, the curriculum in law schools has not been changing at the same speed. I'm not sure about the experience in Brazil, but certainly my sense here in the UK is that for some quite considerable time, PhD students have been choosing topics in law and technology for their PhD theses, and I find myself examining a lot of PhDs in that field, and that's great because many of these PhD students are going to go on into academic careers, and so they're already kind of absorbed and immersed in law and technology, or at least they're their field of their particular focus in law and technology. So you don't have to convert them. And I think at the, almost, you know, as a knock on from that, in the LLM programs, pathways or streams or modules dealing with law and technology, again, are quite commonly found these days, so that we feel fairly confident about opening up our master's programs to law and technology. But the $1,000 question is about the undergraduate programs, where I think we're still pretty conservative. And of course, to some extent, we have to be, because where our undergraduate degrees are giving exemptions for, are related to professional qualifications anyway, then there are constraints on what you can teach. So, I mean, I think in the UK, we see a number of undergraduate programs now making use of the optional space they have, usually in the final year of the program, to offer up some law and technology modules. But you know, it's not quite mainstream yet. And I think that what the law schools should try to do is introduce law to their incoming first-year students in a way that really makes it clear that technology needs to be in the forefront of their attention. As I say, I mean, I went through an undergraduate program in the 1960s without any mention of technology at all. You know, and not just then, you know, for 30 or 40 years afterwards, students wouldn't probably have been introduced to law in the way that, no, because, you know, they would say traditionally we're training students to think like lawyers, and thinking like a lawyer means doing exactly the things that you were describing you were encouraged to do in the law library very early on. You know, how to navigate the materials, how when you're presented with a factual scenario, how to figure out which body of law, where as is contract, is this tort, you know, if it's a contractual problem, is it a problem about performance or damages, what's the issue here, and then to be able to argue the case. Well, I mean, if the instruction is to argue it for the claimant, to be able to present it in the most favorable way for the claimant, and if it's for the defendant, the other way, you know. But anyway, to be able to show that you can not only identify the relevant legal principles, but understand how those principles or rules can be applied in ways which point in different directions, you know, with different emphases. And that, yeah, that's a skill of thinking like that's kind of game, kind of parlor game, you know, a game you might play at a dinner party. Who can make the best job of arguing a case for this side here? But we have to understand that thinking like a lawyer in the 2020s has to go beyond that. So we have to say that to our new students, you know, you're going to have to think outside that particular box. And I think if you say what we're thinking about is governance, and the exercise you would traditionally play is part of governance, but it's a larger field, a bigger picture here that we need to present you very early on, so you have a kind of map of where we are in the whole field of governance, so that even when we're concentrating in a very kind of narrow local way on law, you understand that this is within the broader picture of governance. So I think, you know, we have to emphasize that technology is front and center. We have to emphasize that in the end, our field of interest is governance, that law is part of that we have to think outside the traditional box. But for me, the most important thing is that we have to, I think we have to present lawyers of the future in a much better light than the lawyers of today stand. When I left my school, I was going to go to university to read modern languages. I hadn't thought about studying law at all, but for whatever reason, I decided I didn't really want to do that. And I wasn't sure in those days whether I even wanted to go to university. So, but the idea that I might study law suddenly, you know, occurred at some stage when I'd already qualified to go to university, but wasn't going to take it up. And I was lucky enough to have a conversation with a local lawyer where I lived, in the city where I lived. And I said, you know, should I go to university? That's my first question for you. He said, absolutely, you know, you should go. So, because in those days, only a small number of people went to university. And he said, yeah, it's a great opportunity. You must go if you can. So I said, fine. I said, well, look, the second thing is that I'm not sure what to study, but I'm thinking about law. And he said, well, no, he said, no, you shouldn't, definitely not. He said, studying law would defeat the whole purpose of going to university, because going to university is about becoming civilized. And, and funnily enough, I was reading something by James Dyson, who was a member of the Supreme Court here in the UK and recently retired as the Master of the Rolls. And he was recalling the time, much the time I was having this conversation with this solicitor in the 1960s, when he just left school, or was leaving school to go to, he got a place at Oxford to read law. And he went along to the college in Oxford where he was going to be studying law, so he thought, had a word with the head of the college, who was a classicist. And the head of the college said to Dyson, well, he said, look, you don't want to be studying law. That's a waste of time here in Oxford. Very similar kind of conversation. And it's not just that people think that, that law is not about becoming civilized, but also that lawyers in practice have a rather poor reputation. I mean, there's a famous Harold Lasky, who was a political theorist here in the UK, used to say that after the revolution, it's always the lawyers who are the first taken to the guillotine. That they're not people who seem to have the public interest at heart. And you look at the big law firms and you think, well, what are they really about? Is it about, they're certainly servicing corporations and corporate interests, but what are they really about? Is it in our interest? So I think that to respond to the charge that law degrees are not civilizing, we do have to broaden the scope of our field of interest. And if we say that governance is our field of interest, I can't think of anything more important, because governance is breaking down in many parts of the world. The conditions, the preconditions for governance, for the possibility of governance, are hugely important. And I think lawyers have a tremendously important role to play in helping their communities not only understand the preconditions for governance, but also sort of being able to understand that we have to keep adjusting now to a rapidly changing context in which new technologies are disrupting practices, or in the economy and socially, left, right, and centre. And this is very different from law in a world that is not moving forward in this way. Where conditions are very stable, and we can have governance is governance is relatively easy for a group, because they can lay down the rules. They can say this is our code of practice. And circumstances won't change in ways that dramatically affect that. Because people will break the rules, and there'll be an attempt then to bring them back to where people were, where they should have been standing. But when everything, when it's like being on a roundabout, and everything is changing around you all the time, and it just doesn't stop, then it's not enough just to have put in place a particular set of rules which were right at the time. You've constantly got to be adjusting for the changed circumstances. Law faces, I think, huge challenges now, but it's challenges facing governance generally. And if we don't get it right, then the world becomes much less civilized. And so I think that, the message I want to get across to our law students is that, well, they might have all sorts of reasons for wanting to study law, but the best possible reason actually is that they can contribute in future to the good governance of our communities in challenging circumstances. Whether they need also to be more techie in their skills, well, that's another debate. I'm not sure that that's the really important thing for them to do. It may be that the people who say, oh, they all need to know how to code and whatnot now, for a digital world. Yeah, but it could be other technologies that come back to become really important in 5 or 10 years' time, and we'll be saying, oh, they all need to be geneticists. No, I think the important thing is they understand the kind of things that I've been saying are really important, which is that law is a key component in making for a civilized world.
Thank you very much, Professor. It was a wonderful experience to have you with us today, with the answers and the insights that you provide to us. I would like to also thank our audience to following the interviews that we're having for this project, and for all of the people that are watching. See you next time. Thank you. Thank you again, Professor.
Okay, thanks very much. It's been a pleasure. Thank you. Bye-bye.